All right. Hello, everybody, and thank you for joining us on this Monday afternoon with Britt Burner from Burner Prudenti Law. And I will just hand our Zoom right over to you and let you get started for the year of trusts and any 2025 things we should think about.
Great. Thank you so much. And thank you to the Shelter Island Library for having us, as always, having me. So I am Britt Burner. I'm a partner at Burner Prudenti Law. We have offices in East Hampton, West Hampton Beach, East Setauket, and Manhattan. And we practice in the areas of trusts and estates and elder law. So when I come to you with a topic like today, which is, what do we have to think about here in 2025? We're really focusing on trusts and estate administration after death, and also the administration of your estate while you're still alive, especially in regards to Medicaid and other entitlements that you might be looking for. So I'm going to talk a lot about the things you might have heard before, right? So what kind of documents should everyone have in place? New year, take a new look at your plan. And we're going to talk about those things that you should have in place. And then where appropriate, I'm also going to point out something that maybe we see a change might be coming on the horizon or something you should look out for. That way you can be aware of what might be a little bit different this year as opposed to prior years. But a lot of what we're talking about is just revisiting the things that you've already gone through, that you've already looked at, because it's very relevant to go back and look at those things again. So I'm going to start with the very simple things that everyone should have. And when I say everyone, I mean this first document, I think anyone over the age of 18 should have this document, and it's a healthcare proxy. A healthcare proxy says who makes medical decisions for you if you cannot make them for yourself. That means you've been deemed incapacitated, either a temporary incapacity, such as that you're under anesthesia or something like that, or a more permanent incapacity like dementia, Alzheimer's, or some other cognitive impairment that leads you to be unable to make your own decisions. And so it's very important that you have that document in place, because while there is a default in the law as to who can make medical decisions for you, you might not want the person that falls in your default position. And so you want to make sure. You also want to make sure it's clear that if you want that person to be able to make end of life decisions, et cetera, you need to put in your document that that person can make those decisions for you. You do not need a lawyer to sign a healthcare proxy. You just need two witnesses over the age of 18, and please don't have them be one of the people that you're naming as your agent in the document. You can have successor agents, so you can have person one, person two, even person three, but you cannot have two people acting at the same time. So you must put them in an order of priority of who can make decisions. Along with a healthcare proxy is a living will. A living will is a document that says, generally speaking, if you're in an irreversible state with no reasonable expectation of recovery, whether you would allow or not allow your agent, so we're going back to that healthcare proxy, your agent to make decisions regarding certain treatments. So if I'm in an irreversible state with no hope of recovery, can my agent make decisions regarding giving me antibiotics, kidney dialysis, cancer treatment, cardiopulmonary resuscitation? So can my agent sign a DNR, right? Because the DNR is signed with the hospital. What kind of decisions? Artificial nutrition, hydration. These are the kinds of decisions that we want to know. Are you giving your agent the right to make that decision? Now, you're not making the decision now, and you're not telling them what to decide. You're empowering them to make that decision as they think you would make it. Could you speak for yourself? It's also important that if there's people that you want to have access to your medical information, that you sign what's called a HIPAA release or a HIPAA waiver. HIPAA is the law that gives you privacy over your healthcare information. And so you have a healthcare proxy, and it says your healthcare agent can get HIPAA protected information, meaning information protected by that law, but only if you're incapacitated, right? Because that healthcare proxy is only in effect if you're incapacitated. So if you want access to your healthcare information to be given to other individuals, regardless of your capacity, then you can also sign this HIPAA waiver. Now, I said the healthcare proxy requires two witnesses over the age of 18. Same with, excuse me, same with the living will. 2 witnesses over the age of 18 should not be the individuals that are named as your agents. The HIPAA release actually doesn't require any witness, and none of the 3 documents require a notary. So 2 witnesses for the first 2 documents and nothing, no witness, just your signature and a date for the HIPAA release. Along with the healthcare documents, we want to make sure in 2025 that everybody has an updated power of attorney. Now, in some states, they use the term medical power of attorney versus financial power of attorney. In New York, we don't do that. In New York, we have the healthcare documents as I described them. And then when we say power of attorney, we're referring to a financial power of attorney. Now, not all powers of attorney are created equal. So the question is, what powers does your agent have? Well, it depends what powers you've given your agent in the document. So when you look at it, you say, okay, I give my powers A through O, right? Those are the standard powers in the document, and you initial at letter P, and it says I give all the above listed powers. But then there's a modification section. And within that modification section, you can expand upon the powers that your agent will have, including gifting. You have to specifically state if your agent's allowed to gift. Now, a lot of people would say, why would I want my agent to gift? That doesn't make sense. I don't want them giving away my money. But realize that gifting includes a lot of different things. So if there's one spouse has an account in their name, and we have to move the account from that spouse over to the other spouse, maybe for some Medicaid planning, that's a gift, right? Moving it from one person's name to another. So are you going to allow that type of transfer? Another example, if you have a trust and you're moving assets into that trust, that is gifting to the trust. If you don't yet have a trust, are you going to allow your agent to create a trust on your behalf if that's determined to be in your best interest at the time? So you want to think this through with a qualified attorney to discuss, do I want gifting? In what circumstance do I want gifting? And what powers do I need to add to that modification section of the power of attorney document to allow it? Too many times people come to us and they have a power of attorney that was done quickly and they got it from someone they knew, and it either isn't the right form, so it's not valid, or it's valid, but it does not give expansive powers. So the thing that, mom or dad is incapacitated, child is there with a power of attorney that they think gives them all-encompassing power. And in the end, the powers that they need to really get the assets protected, move things around, they cannot do. I'm going to talk about estate taxes in a little bit, and gifting in terms of estate taxes. If you become incapacitated and you can't do that type of gifting, you might be in a place where your power of attorney, or if you don't have a power of attorney, can't do the things necessary to save your estate from large estate taxes. So it's very important to make sure that you have the right powers in that power of attorney to cover your situation. Then moving on from that, we're going to talk about wills. So a last will and testament is a document that says what will happen with your assets at the time of your death and who you would like to be in charge of that. We call it the executor. Now, it's important to realize that your executor is nominated by you, but chosen and appointed by the court. So your will must go through a process called probate. And at the end of that probate process, the executor gets appointed by the court and gets a certificate saying that they're the executor and they can collect the assets of your estate. But until that time, they don't have any power over your assets and they have no job to do. And your will is only going to go through this process of probate if there's a job to do. So for example, if somebody has very often, let's talk about spouses, right? 2 spouses, all their assets are joint, or maybe they have some retirement accounts or life insurance, and that names the other as beneficiary. In that case, when the first person dies, there might not be probate because all the joint assets go to the joint owner, and anything with the beneficiary goes to the named beneficiary or beneficiaries. So very often there isn't probate in that first instance. or even if it's not spouses, even if it's somebody who has a bank account that they all have beneficiaries on them, or they have a child that they've made joint on something. In those cases, those assets will not go through probate. But as soon as you have one asset, even one that does not have that joint owner or beneficiary on it, then we end up in a situation where the court has to be asked for somebody to have control over that asset. And when you have a will, the way of asking the court is through that process called probate. Now, commonly, all the time, people come in, they say, I have a good will, I don't have to probate. You could have the best will in the world, but if there's an asset in your sole name with no beneficiary, it must go through probate. And the purpose of probate is so that your bank or whatever, wherever the asset is held, knows that the right people are in charge of the account or the asset and that your will was valid. So let's take a common example. Somebody dies, and a family member takes the will. They're probably named as executor in the will. They take the will and they go to the bank and they say, there's this $100,000 bank account. I'm the executor. Here's the will. Can I have the money? And the bank says, no, you need a letter from your lawyer. This is the terminology that's often brought to me. What they're actually saying is you need letters testamentary, which is that final product of probate, which says the executor is in charge of the money and the bank can release the money to that person. And they can open an estate account and move the money into it, pay the bills and expenses, and then distribute out to the beneficiaries. So if you are in that case and they say you need a letter from the lawyer, that's what they're talking about. They're saying this will has to go through probate. So that original will, a death certificate, and a petition for probate goes into the court, and the individual's legal next of kin get notified. So for example, if you're a person who has a spouse and a child, those are your two legal next of kin, according to the state of New York. They receive notice that your will is going through probate, and assuming nobody contests and there's no issue, probate completes and the executor gets appointed. But let's take somebody with two children and they're leaving 100% to one child and nothing to the other child. And the will says something like, I leave nothing to my second child, and they know why, because they know what they did. This is another thing we see quite often. Well, in that case, the second child, who may know why and may know what they did, still has to get a copy of that will and either sign a waiver of probate saying, yes, I'm not going to contest this, or the court's going to issue that person a citation. And they're going to have a date and a time that they can come to court, and they can say to the court, I don't believe that this will should go into probate, and this is why. My mom was under duress when she signed it. That's not even her signature. She didn't have capacity. There's certain things you'd have to prove, and that's when things start to get messy. So a will, the process of probate is to determine, is this a valid will or is there something we should be concerned about? So someone that's disinheriting that next of kin should be worried. They should probably want to avoid probate. Another person who should want to avoid probate is that person who doesn't know who their next of kin are. All too many times somebody comes in and they say, my situation is very simple. I have no family. Well, that to me is a red flag, right? This is someone that we want to avoid probate on, because they may feel very comfortable leaving all of their assets to the Shelter Island Library or some other charity, but that still doesn't mean that we don't have to notify the next of kin. And we have a lot of cases where we have to call in a genealogist to go searching for who these next of kin might be. And, we have searches that are going into other countries, into Europe, because they need to be identified to satisfy the court that the next of kin have been notified that this will is going to probate and given an opportunity to come in and contest. And so this process of probate can be very simple if you were in that first circumstance where I said, you have one spouse, one child, everybody signs off, no problem. Or it can be incredibly difficult if you're disinheriting that person, or if you can't locate who those next of kin are. It can be very expensive and take a lot of time to go through the process. All in the meantime, the assets are frozen in the estate. So you really want to make sure that you're avoiding probate if it makes sense for you. We also like to avoid probate if somebody has a taxable estate. So in general, it's over 7 million, although I'll talk about the tax numbers in a minute. So if you have more than 7 million, we probably want to avoid probate because we want to avoid delay because taxes are due when they're due and there's no leeway on that. And so we want to make sure the executor is immediately, or whoever it is immediately in control of the assets to do what they have to do. You want to avoid probate if you have disabled beneficiaries or maybe even minor beneficiaries, so children or grandchildren, because in the disabled person who can't represent themselves in the proceeding or the underage person, the court will appoint a special guardian for the purpose of the probate proceeding. And so you want to make sure that you're not creating additional costs and delay on your estate. So then that brings us to how do we avoid probate? So the main way that we avoid probate, which is what I started with, is you name a joint owner or a beneficiary on your assets. Now, this is not going to work for every person and it's not going to work for every asset, but where it does work, it certainly does the job. So if all you have is a bank account and a retirement account, then you put beneficiaries on those and you're in a good position to have your estate handled without court intervention and without notification of those family members. But let's say you have properties. I should also have added the other reason we often like to avoid probate is if you own property in multiple states. So if you are a primary resident here in New York, but you own a small cabin or a large cabin, but even the smallest of cabins in another state, Pennsylvania, Massachusetts, whatever it is, you have to probate your will everywhere that you own dirt. And so a lot of people don't realize it, but they're creating a situation where their will has to get probated here in New York and then down in Florida for the condo and then in Pennsylvania for the ski house or whatever it is. And they're creating more process at the time of death than they meant to. Now, for someone like that, they would often want to create a trust. And that trust exists and you create it in the state in which you're a primary resident. So in my example, the New York person opens a New York trust. And then you would sign a deed for each property, moving the property into the trust. So the trust would own your New York residence. It could own your Florida residence. It could own your Pennsylvania residence. And then at the time of your death, because the trust is the owner, therefore it's not in your sole name, we don't have the probate of the will for that asset. It passes according to the terms of the trust. Now, a trust document is very similar to a will in that it says who's in charge after your death and how things should be distributed. But the difference is you create a trust while you're alive and you put things in it while you're alive. You might have heard the term living trust. What that means is it's a trust that you create while you're alive. And then when you title assets to the trust, you make your bank account in the name of the trust, you make your property on the deed in the name of the trust, then you're removing it from your own name. Now, that doesn't necessarily mean that you won't be taxed on it or any of those things. It just means we're avoiding probate. That's a revocable trust often. So a revocable trust, the only thing that it's doing for you is avoiding probate. It's a great thing, but it's not saving on taxes. It's not helping with Medicaid planning. It's just avoiding probate. And a lot of people will do that in order to organize their estate in a way that it's more efficient at the time of their death than having to wait for this probate process to go through. There's many different types of trusts. There's revocable and irrevocable. Those are kind of the big highlights for living trusts. Revocable, I just described, avoids probate. An irrevocable trust can be many different types of trusts. It depends how they're written and what you're trying to do. So sometimes an irrevocable trust is created to move assets out of your name for estate tax purposes. So if you're losing access control, someone else is the trustee and the trust is drafted properly, then when you get to the time of your death and you add up all the money in your estate, New York State isn't going to look at what's in that trust. So sometimes we use that as a tool. There are irrevocable trusts for Medicaid asset protection purposes. Those do not remove them from your estate usually for tax purposes, but it does make it so that the assets are protected should you need home care, or after a 5-year waiting period of assets being in the trust, nursing home care. So some people are creating Medicaid asset protection trusts, which are a type of irrevocable trust, in order to protect certain assets. So if they need that care down the line. For example, someone who has a primary residence and wants to make sure that if they should need care in a nursing home or long-term care in their home, that care could be paid for, but that house could still be used for them for their lifetime and then pass on to their family. They will often create an irrevocable Medicaid asset protection trust and move the asset, the deed of the house, into the trust. And then it continues to be your trust for your lifetime. If the trust is drafted properly, you continue to get all of your real estate exemptions. If you have a veterans exemption, a star exemption, you might have an enhanced star exemption. All these real property tax exemptions remain yours. And at your death, the asset gets a step up in cost basis still to your date of death value. So what's that? Let's say somebody bought a property out on Shelter Island for $50,000 in the 60s. And now upon, let's say it's worth $1.5 million now, right? This is not an uncommon story. The numbers might be different, but we see this a lot. So let's say that now there's been that enormous gain in the property value. If that person sells it now while they're alive, they're going to end up paying a capital gains tax on the difference between what they purchased it for and what it's worth now. Now, there's some exemptions in there for capital improvements put on the house. If it's a primary residence, there's an exclusion of $250,000 a person. So if it's 2 spouses, it could be $500,000 total. But that's likely to create a gain that's going to have to be paid, a tax. But if that same person owns that property in their own name at the time of their death, or in a revocable trust that does nothing tax-wise, or in a Medicaid irrevocable trust, then at their death, it'll step up to their date of death value. So if it's worth $1.5 million at the date of death, and the family members turn around and sell it for $1.5 million, there will be no tax paid. All that gain gets wiped out. And so a lot of people who are creating these Medicaid trusts are very concerned that they preserve that gain, that step up, the ability to wipe out that gain for their family members. And so with that Medicaid trust, we can still do that. And that's really important for a lot of people. But during your life, it's still yours. If you rent it out, you can get the rental income. It is fully yours. The trust just needs to say that you can't access principal. So let's say you do sell it, you paid the capital gains tax, you sell it, now this money is in the trust, you can't use the money. And that's what makes it protected for Medicaid purposes. That's the important part here. So that's what we do often with trust planning. So when we talk about the plans that you should be making for the year ahead, if you have one of these trusts, you should be looking at it, reviewing it, making sure it still makes sense based on your age and circumstances, your family circumstances, and your assets and your needs for the future. And you should also be looking, if you don't have these types of trusts or vehicles, at what you might need. Is there something that you didn't think about because you were working previously and you weren't so worried about planning your estate, or you weren't thinking about long-term care, but now you really need to figure out how you would fund that? So you should be looking at this depending on what position you're in personally, as what should you be looking forward to and what should you be creating. I'm going to stop and answer questions up to that point, and then I'm going to start to talk about taxes in terms of the federal and New York State estate taxes, and also some Medicaid things. So I see there's a question here.
Yes, we have a question here, and then we have a hand raised as well. Um, So the first question is, if all of my assets are in New York, does my son who lives in another state need to use a New York lawyer with a living trust?
I'm going to answer that one, but the person might just have to write in a clarification. So if all of your assets are in New York and you're creating a trust for, even if it's for the benefit of your son who lives elsewhere, you create a trust with a lawyer in the state in which you are a primary resident. So it'd be appropriate for you to have a New York lawyer that you meet with and you create your estate planning documents. Upon your death, if your son is the trustee and therefore he's going to be in charge of work, gathering and then distributing the estate, then again, he'll probably use or should use a New York based lawyer who's licensed in New York in order to do so. I think that answers the question. Please let me know if you need a clarification.
And then we have another question that asks, is primary residence exempt from Medicaid recovery after you die if you only used home care and if you have a revocable trust?
Yeah, so the law says that Medicaid can only claw back at your death for assets that go through probate. So my whole long description before about what goes through probate versus what doesn't, in that person's example, if your home is titled in the name of your revocable trust, then upon your death, it avoids probate and therefore Medicaid can't put a lien on it. Now, it gets a little more complicated because depending on the county that you're in, whether or not you'd be deemed eligible with your home in a revocable trust is a little bit of a gray area right now. But if you are receiving Medicaid and your home is in a revocable trust, then yes, you cannot be recovered against at death by Medicaid. They can't touch anything that doesn't go through probate.
Shelley, you had a hand raised. Do you have a question for Britt?
Oh, I didn't mean to. I only am just so grateful for this presentation. It's so much help. Thank you.
Oh,
Yeah.
absolutely, no problem. We have another question that asks, can I write a trust where the beneficiary gets funds after both my husband and I die?
Yes, and that's quite often what's done, but sometimes it's different. But yeah, a trust, it's very interesting because you can really say whatever you want. So when I'm talking to people about trust, I always say, you tell me what you want, and then I'm going to put it into the legal terminology. And so sometimes people say, when my spouse, if I die first, then my spouse can have whatever they want, but then when they eventually die, this is how we want it distributed. Or some people say, when I die, I want to make sure that my niece gets $20,000 right off the bat. I don't want her to have to wait until my husband dies. She was always so kind to me, and I want that as a gift. And so you can say, even if my spouse survives me, 20,000 off the top to my niece, the balance, etc. So you can create what you want to happen. And often our trusts create further trust. So our trust might say, when I die, then this is the new set of rules. And then when my spouse dies, then this is what you should do. And so it's important that your trust be very clear. We always say clear is kind. The more words in your trust, assuming it's written the right way, the better it is. Because if we have a trust that really just leaves a lot of things up to assumption, that ambiguity is what creates litigation around trusts. So we really like to be as clear as possible as to what you're looking to do.
All right. And then we have another question that asks, what happens if your co-op apartment or house is in the Medicaid trust, but you need nursing home care before the 5 years are up? How do you pay for nursing home care, and or can you sell the co-op to pay for a nursing home?
So this is going to be very person specific, but the short answer is if you have an irrevocable Medicaid asset protection trust and you have transferred an asset into it and 5 years has not gone by, then you are not eligible for Medicaid. So what to do and how to pay for the nursing home, I should say you aren't eligible for nursing home Medicaid. So what to do and how to pay for the nursing home is going to depend on the individual circumstances. It's going to depend on how far into the 5 years we are. Is it worth it try and push to get through the 5. You know, are we in year 4? Are we at 4.5, or are we at 6 months, right? So it kind of depends. What other assets are available? Are there retirement accounts? So it's going to be very person specific what to do, but there's no prorating that happens here. You get through the 5 years or you don't. And when you have an asset as big as a co-op or a house, it has to be the full 5 years.
All right, thank you. And someone asks, if we wanted to meet with you in person, do you have a Nassau County office?
I don't. We have offices in Suffolk and in Manhattan. We often meet with people on Zoom and then they come to our office for the final appointment. But if somebody wants to meet with us, you can certainly give the office a call and we can run through options with you. Thank you.
Okay, great. And I'll also put the link to the Burner Prudenti website in the chat as well for everyone. And we have another question that says, I have a will with no trust, and I do not want my sister to get anything, only my husband.
So, that might be fine. So I think what that person's getting at is the next of kin issue. So if you have a spouse, we don't get to your sister when we look at who your next of kin are. So your spouse is your first next of kin along with your children. So for example, if someone is unmarried and doesn't have children, then their next of kin are their parents. And if your parents are deceased, it's your children. So, sorry, if your parents are deceased, it's your parents' children. So then it would be your sister. So if this person's asking that question, if you have a spouse who's living, then it won't get to your sister. But if your spouse dies before you and you don't have children, your sister might become one of those people who gets the notice of probate. Now, that doesn't mean that she's going to contest, and that doesn't mean she's going to create a fight in court, but that is who would get notification of what was going on and a copy of your will.
Okay, thank you. And then this last question here is the first visit with you complimentary? And I
Well, we charge a $500 consultation fee that we apply towards the cost of the work we do.
All right, great, thank you. And again, I have the link to the Burner Prudenti website in the chat for anyone who would like it.
Great.
That seems like the questions for
Okay.
right now.
I'll get into part 2 and then we'll go back for more questions.
Perfect.
So everything we just talked about is kind of what if you've listened before, you've heard about it before. And if you've met with a lawyer and you've done your estate planning, you probably heard about it before. They're pretty standardly the documents we like people to think about having. But now let's talk about some things that might change from year to year. So taxes. So every year, the government, both the federal and the state, come out and tell us what is the amount of money someone can leave behind without having an estate tax. So if you have under this number, there's no tax. So in New York State, the 2025 number is 7.16 million. So if somebody has less than $7.16 million, when you add up their house, their IRA, their life insurance, all their assets, then there's no tax. However, realize that in New York, we have what's called a cliff. So if you hit 105% of that, which I think gets us somewhere around 7.5 million, then you fall off the cliff, which means you have no exemption and you're taxed from $1. So if you have an estate that's at that, let's say $7.8 million, you're probably looking at about a $700,000 tax right off the bat for New York State. So you want to be looking at, if your estate is creeping up towards that amount, what do you want to do to reduce it? Now, in New York, there's a few things you can do. One is we can say, I have some clients that just say, I know I'm going to be just a small amount over. So anything that I'm over, give to charity. And that gets me right back underneath. And you name who the charity is in your documents, and that might do it. Or you might give a large asset to a charity knowing that's going to bring you under. So charitable giving is one example. There is certain planning we can do with gifting. So in New York State, you can give a gift of any amount and you will not be taxed on the giving of that gift unless you die within 3 years. So if you are at 8 million and you give away $1 million to get yourself back underneath, as long as you live for 3 years after you give away that gift, that $1 million that was given away will never be taxed. It won't be part of your taxable estate. And in New York, we don't have a gift tax. So that's something else that's important to realize. But it's different on the federal side. So if that is something you're looking to do, don't tune out when I start talking about federal taxes. But yes, if you have under 7.16 million, you don't have to worry about estate taxes. If you're over that, you want to be meeting with an attorney, your accountant, a financial advisor, and talk about ways that you can reduce your tax burden or the tax burden on your estate, meaning on the people you're leaving things to when you do pass away. So that's an important number to know for this year. On the federal side, we have an incredibly high tax exemption right now. It is up to $13.99 million. This is per person. So that means that a couple can leave just under 28 million. Now, this is a really important thing to pay attention to because 2025 is a pivotal year for this number. The Tax Cut and Jobs Act, which was passed in the first Trump presidency, put this inflated exemption amount into place, and it's indexed for inflation, so it goes up every year, just as the New York State does. But at the end of 2025, that law says that this number will sunset, and it will go back to the 5 million index for inflation, which will probably be somewhere around where New York is, let's say 7-ish million. So 14 million this year, but if you die on day one of 2026, we're down to 7 million federally. So you really want to pay attention to what's going to happen with that law. Now, we don't know what's going to happen, right? So there will have to be some sort of action by the federal government to either extend this further or to reenact the higher number. But we have to watch and see. So if you are someone who's concerned about those higher numbers because your estate is such that it would be a problem for you, you want to watch this closely to see what is going on. But we don't yet know what's going to happen. But all I know is that the current law reads that there is a sunset at the end of this year. Now, there is a gift tax in New York, in the federal side, though. $19,000 per year can be gifted estate tax-free, gift tax-free. So what does that mean? That means that I can give everybody on this webinar $19,000. I don't have to file a gift tax return. Nobody's ever going to ask me for taxes on that. But if I were to give everybody on this webinar $40,000, then for each person, I would have to file a gift tax return for $21,000. And on the federal side, all of those would get added up and go against my lifetime exemption, which this year is 13.99 million. So the people who have to worry about this gift tax amount are the people who are worried that they might be over the exemption amount. If you're worried you're going to be over the exemption amount, you want to make sure that any lifetime gifting you do is part of a plan that takes that into account. Because basically they're placeholders on your estate and they'll all get added up and then there'll be an estate tax determined based on how much you gave during life and death. So that's a big difference between the state and the federal. And that number has just slowly increased. Years ago, it was 10,000, then it was 13, 15. Last year, it was 18,000, and now it's 19. Now, as a single person or as an individual, I can give 19,000 to any person. My spouse can also do the same. So there is a way to really compound the gifting, and that can really make a big deal over time if done as a plan of gifting. So on the federal side, that is a big difference from the state side, this gift tax concept. Another big difference between the federal and the state is that in New York State, our exemption, our 7.16 is use it or lose it. So if I die and everything goes to my spouse, because remember, I had it all joint beneficiary designations, my spouse now owns everything. But now my spouse, with my spouse's assets plus my assets, my spouse has $9 million. Well, when my spouse dies with a 7 and change exemption, my spouse is going to have a taxable estate, and the beneficiaries are going to have to deal with the fact that there's a tax that's going to have to be paid off the top of the estate. And so if you want to take advantage of both spouses' exemptions to essentially get a double, right, to get 14 plus an exemption amount, you need to do planning. So you should be talking to your lawyer about what we call bypass trusts or credit shelter trusts, where your estate planning documents capture your exemption so it doesn't all compound in your spouse's estate. That doesn't mean your spouse is going to lose access to that money, but it does mean it's going to protect the eventual beneficiaries from large taxes. So you want to be looking at that in New York, especially. Now, on the federal side, we can still use those techniques, but they're not as important because there's something called portability. So the federal government allows us to save an unused exemption from one spouse for the other. So in my same example, if everything is joint and my whole estate goes over to my spouse, and my spouse files an estate tax return saying, my spouse died, I got all the money, there's no taxes because I'm a spouse and I don't pay taxes, but I want to elect portability, I want to save it for later. Well, then my spouse, when they eventually die, they'll have whatever their exemption is in that year, plus the 1399 from this year's death of the first spouse. And so very easily you can save that exemption and use it all later. And so these are the different types of things we think about when we're looking to plan as to how assets should be distributed between the spouses and trust planning and things like that. That's also one of the reasons I said that those who have a taxable estate should be looking at avoiding probate and having trusts, because it makes the administration of these ongoing trusts a lot easier. So I don't see that, there's no proposed change in 2025 in terms of the New York State law on estate taxes. We do see it goes up a little bit every year, but there's nothing really to watch there. Whereas on the federal side, it's a very big year for what's going to happen with this estate tax scheme. So you should definitely be watching that. I'm gonna move on to some Medicaid things next, but I just want to stop and see if there's any questions up to this point.
We have one question which asks, if you have an $8 million estate, can you divide it between the husband and wife?
Okay, so I think I might have just answered that, and this question might have been before that, but I will say, yes, you can. If when you add it all together, it's 8 million, you want to make sure that that second spouse doesn't end up with that full 8 million, because then there's going to be a tax unless you're giving, a million of it or so to charitable beneficiaries. You want to make sure you're not going to compound the estate. So you definitely want to make sure you're doing proper planning to split up the estate so it utilizes both spouses' exemptions on the state side. Okay, so now I'm going to just talk about some Medicaid things. So Medicaid is a program that many people over 65 will use for the purpose of long-term care. So I'm not talking about everyone who uses Medicaid. There's plenty of people who use Medicaid for other reasons, but what I'm referring to is Medicaid for what we call dual eligibles. So those that are eligible for both Medicare, as many people are, most people are when they turn 65, as Medicare as their primary insurance, with a Medicaid supplement to pay for additional services. So Medicare is still going to pay your hospitals, your doctors, your rehab, and other things, but Medicaid is going to pay for additional services, most often, importantly, the home health aid or nursing home care. These are not covered by your Medicare. And so a lot of people need to seek the assistance of the Medicaid program because those costs can be astronomical. And while they may have some assets, they don't have enough to fully fund their care. So in terms of the federal government and what to watch in terms of Medicaid, sure, there could be cuts that come from the federal government on the Medicaid programs. Medicaid is a state program that has federal money. So the state runs it, and there are federal Medicaid laws, and then the state can really alter from those. So for example, New York is going to have a very different Medicaid program than Florida or Texas or some other state. So it is very New York specific, but we still do rely on a lot of federal monies. And so that's definitely one thing to watch in terms of Medicaid. No indication yet for what that will be, but it's something we're definitely looking at. On the state level, there's always changes to the Medicaid program, but nothing is on the horizon at the moment that's incredibly concerning. If you watch, when I watch Sunday morning news shows, I've been seeing this public service announcement for the Commissioner of Health, for the Department of Health, who's been talking about changes to the CDPAP program, the Consumer Directed Personal Assistance Program, and promising New Yorkers that him and the governor would never take away their right and that they have them protected. And what they're talking about is a recent change in the Medicaid law that changes the number of what we call fiscal intermediaries. So it centralizes the system that pays Medicaid funded aids. And so a lot of people in the disability community or older adults utilize this program to have their one-on-one home care provided, and they're changing the way that those caregivers are getting paid. And so that's been a big issue within the state, and we see it on our TVs. This year for Medicaid eligibility, again, I'm talking about the over 65 dual eligibles who are looking for home care or nursing home care. We base our Medicaid eligibility numbers on the federal poverty level. So you're allowed to have in monthly income, for example, 138% of the federal poverty level. So that is just under $1,800. So let's use 1,800 as an example. So if somebody has Social Security, a pension, and required minimum distributions from their IRA, if they have more than $1,800 monthly from those sources of income, then they have to, if they want home care assistance, put their income over that 1,800 into what's called a pooled income trust to protect their income, to keep paying their bills so that Medicaid would pay for their home care. I'm not going to dive heavily into the pooled income trust today because that's a whole other hour that we could always do. And I think we have done before. We could always repeat. But there are ways to protect income when somebody's at home. Once someone goes into a nursing home, your income goes to the facility and Medicaid pays the balance. So your income is going to be lost unless you have a very low income spouse at home. A spouse can keep certain income in certain circumstances. On the asset amount, so this is what can be in your bank accounts, what assets you can own, you're allowed to have just over $32,000 this year. So again, let's just for round numbers say 32,000. So when I add your checking, your savings, if you own life insurance, is there a cash value? These are all assets that are available to you. And so they are counted and they have to be under that amount or else you don't qualify for Medicaid. If you have a tax deferred retirement account, so if you have an IRA, a 403B, a 401k, those do not count as an asset because you're taking those distributions, they count as income. So you're allowed to have, for example, $32,000 in your checking and $100,000 in your IRA. The IRA, as long as you're taking that distribution from it, you don't have to worry about that making you ineligible for Medicaid services. So those numbers have gone up. So as we sit here at the beginning of February, we're up a little bit higher, only about $50 or so on the income, but it has gone up a little bit since last year because the federal poverty level has raised. And there's nothing again specific that we're watching with Medicaid, but we're always watching on the state level to see if there are any drastic changes being proposed by the legislature or the governor to see how it's going to affect people. I can tell you that in the current proposed budget that's been put out, there are not major changes that will impact this population. And so it's a little quiet on the Medicaid front in New York State right now. Okay, so I'm ready to continue taking questions.
Okay, we have a question. If a person has no will, is single, has never been married, has no children, and both parents have passed away, but they have one sibling, what would happen to their bank account?
So I would recommend that that person have a bank account that has a beneficiary listed on it. If you don't want to make someone a joint owner while you're alive, which makes sense on your bank account, name a beneficiary, it will go to that person. If not, it would depend on how much is in the bank account at the time of death. If it's under $50,000, if it's under 30,000, we can often do, the bank will often let somebody do an affidavit But that should be someone who's either, would in this case either be the one sibling, or it could be if there was someone who paid the funeral and has to be paid back, that person usually can receive it. It's through an affidavit. But usually that's if they have no will, it's going to go through a process called administration, which means that the asset would go to the one sibling. If it's under 50,000, we can do what's called a small estate, which is just a little bit quicker of a process and a little less involved, but it would still, without any beneficiary, it would go to the sibling as next of kin.
All right, thank you. Let's see. Do we have any other? Oh, yes, we have. So, yep, I was waiting for it. Okay, so the first question, are there any special considerations when giving guardianship to an adult child of undocumented parents in light of recent efforts to end birthright citizenship?
I'm sure there are, but I can't even begin to dive into that here. But that's an interesting question. I have not spent a ton of time looking into that, but yes, I'm sure there are, adult guardianship, deeming somebody incapacitated, and the requirements of who is notified and then who becomes guardian. My guess is an undocumented parent couldn't be the guardian of an adult child. So I think that's a very sensitive circumstance and might also depend on what part of the state you're in.
Okay, thank you. We have another question. My father's in a long-term care facility. He just recently was approved for Medicaid. My mother did a spousal refusal, and the house is now deeded to her, and most of his personal finances were moved over to her. If my mother passes before he does all of her money go back to him, and therefore will he get kicked off of Medicaid? She has a will, no trust.
It depends on what the will says, but probably. So very often when we have somebody in this circumstance and we have to move the assets over to one spouse so the other can get care, we like to do special estate planning for in this case, the mother, to make sure that if she does die first, that we can protect as much of the assets as possible. So it's really going to depend on the individual assets, et cetera. But that person should definitely speak with an elder law attorney about how to make sure you're protecting the most amount of assets should that happen. Also, remember, we said earlier, Medicaid can recover from somebody's probate estate. And so if dad gets Medicaid, which he is, when mom dies, when the second of them dies, if those assets go through the probate of mom's will, even if mom dies after dad, especially if mom dies after dad, Medicaid can put a lien on mom's assets for Medicaid that was given to dad, because mom's, even with a spousal refusal, is a legally responsible relative. So if that's the case, this person should, these set of circumstances, that person should definitely be working with a lawyer to make sure that mom and the assets are protected at each subsequent death.
Right. Another question asks, is it a big deal to put a house which is in joint ownership into a trust?
I mean, but I always say, what's a big deal? Because what's a big deal to one is not to another. I mean, we do it every day. It's very common. And so for us, no, it's not a big deal.
All right. And how is Social Security considered relative to Medicare eligibility?
Yeah, I'm going to assume that person means Medicaid eligibility. So Social Security income is just another stream of income. So it is, if when you add up all your pieces of income, including your Social Security payments, if it's over that 1,800, we've got to protect that if you're on home care. If it is under, like in that person who said their father was in a facility and 600, we can assume 600 is what, well, I guess we don't know what the mother's income was, so maybe that's more complicated. But usually you have an amount that goes over to the facility every month. That's called NAMI, net available monthly income. So if you're a single person and all you have is Social Security and it's 1,500 a month, then that 1,500 is going to go to the facility and Medicaid's going to pay the balance.
All
But they
right.
treat Social Security income like any other piece of income.
Okay, thank you. Let's see if we have any other questions coming in before we reach our end. Let's see. Mhm. All right. Does anyone have any final questions for Britt?
I think they're
All
done.
right. Yeah, I think that might be it. Um, all right. Well, then I guess we'll wrap this up. Again, thank you so much for coming out and speaking to us. We always really appreciate it. Um, uh, we have one last minute question. Should we wait to hear the 25 changes before doing a trust? So I'm assuming 2025 changes.
So I would say it depends, right? So it depends exactly what your assets are, what you're concerned about. I wouldn't wait. I would say that if you have no estate planning, you should have estate planning in place now with an eye on exactly what you would do if things changed on the tax front. I mean, there is going to be a change. The law sunsets. So no matter what, we have to get a new tax law in place. But you know, just like that 2020, whatever year it was, Tax Cut and Jobs Act, that changed not just the state taxes, it changed all these other parts of our tax plan. So I don't know if we're going to see a broad sweeping tax bill or if we're going to see something really narrow just about this sunsetting of the estate tax. So I think it's good to get started and especially have that rapport and make sure you like your attorney so that you know you're on their radar and they're on your radar for when these changes do happen.
All right, great. And then we have someone who says, this was a marvelous presentation. So much information communicated professionally, clearly. Thank you so much.
My pleasure.
Um, yep. And again, like we love having you. Keep your eye out for the next presentation we'll have with Britt coming up. And her website, Burner Prudenti Law, is in the chat if you need it. And a recording of this presentation will be made available in a few days. So again, thank you so much, Britt, for coming out.
Yeah, thank you. Have a good day, everyone.
All right. Goodbye, everyone. Have a good rest of your Monday.